Hi guys, welcome back to my channel. So today in this video I would like to read an article entitled Are the UK's Maritime Migrant Pushback Plans Legal? The UK Home Office has unveiled plans to use turn-back tactics in the English Channel, with the border force compelling small boats carrying migrants to return to French waters. The move is the latest in a series of strict immigration policies by Home Secretary Priti Patel following the introduction of a conventional nationality and borders bill in July that seeks to criminalize arrival in the UK without permission. The practice of turn-back or pushback of migrant boats is not new. Australia, Greece, and Italy have all been criticized for similar policies, with the UN Special Rapporteur on the human rights of migrants calling it a cruel and deadly practice that states must end immediately. More than 13,000 people have crossed the English Channel so far in 2021. The ongoing humanitarian crisis in Afghanistan highlights why people risk their lives making dangerous journeys in small, unsafe boats. As the Strait of Dover is the busiest shipping route in the world, pushback could be extremely dangerous. Reports suggest that UK's turn-back policy is only applicable to sturdier, bigger migrant boats and in very limited circumstances. The government says it has legal advice that allows it to do so under maritime law. So is it legal? It is a fundamental and long-standing obligation of international and maritime law to render assistance to persons in distress at sea. Article 98 of the UN Convention on the Law of the Sea, 1982, or LOSC, mandates that every state require its ship to render assistance to any person found at sea in danger of being lost. The Convention also places a duty on states to operate an effective search and rescue service and to cooperate with neighboring states. The International Conventions for the Safety of Life at Sea and the International Conventions on Maritime Search and Rescue also recognize this obligation to assist. Gerald Darmanin, the French Interior Minister, has stated that France would not accept any practice that breached the law of the sea. Indeed, implementing a blanket turn-back boats policy would be to break international law. The UK government claims it can lawfully utilize this practice in a limited and specific way. Certain boats in particular circumstances but is yet to confirm how Perel has become the first Home Secretary to establish a legal basis for this. Foreign vessels have a right of innocent passage in a state territorial sea up to 12 miles from shore under Article 17 LOSC. If passage is not innocent, such as when domestic immigration laws are breached, states can take necessary steps to prevent passage. For seaworthy vessels, this is generally unproblematic. It may be the UK government expect to rely on some iteration of this principle. But if a vessel determines and justifies that it is a distress, it can enter the state territorial sea. According to an exception in Article 18 LOSC, the duty to render assistance is also still applicable, even where the state believes that migration offenses have been committed by those in peril. French say that the turn-back policy would negatively impact its cooperation with the UK. There are no international waters in the Dover Strait, the narrowest part of the channel, which is divided between the UK and France's territorial waters. France simply may not permit the UK into their territorial waters if returning migrants by force, triggering a standoff. Human rights. Beyond the law of the sea, when officials start to exercise effective control over another vessel at sea by rescuing or physically towing boats back, human rights obligations come into play. Irsi Jama versus Italy, a case considered by the European Court of Human Rights, involved Italian authorities' interceptions of migrants at sea, forcibly returning them to Libya. The court concluded that the applicants were under the contiguous and exclusive de jure under de facto control of the Italian authorities during the transfer, meaning Italy had an obligation to protect their human rights. Human Rights at Sea expert Sofia Galani also affirms that people in the territorial waters of a state are within its jurisdiction for the purpose of human rights, which the state must respect and protect. Such right would include giving people access to a procedure that determines their refuge status and ensuring that there is no collective expulsions of people. In the Hirsi case, the court held the Italian authorities violate the European Conventions on Human Rights by non-examining each applicant's individual situation. When official turns back boats, they risk breaching the right and obligation enshrined in international human rights law. The exercising of this right is not affected by any potential migration offenses that may have been committed. They could also be breach or refuge law depending on the circumstances, such as the principle of non-refoulement, which prevents states from forcing asylum seekers and refugees back to a place where they may face persecution. There is no obligation on international law to seek asylum in the first safe country, and there are many reasons why individuals choose not to do so. Political sociologist Lucy Maplin states that there is virtually no way for refugees to safely and legally travel to the UK due to carrier being fine is if they transport individuals without visas and tight controls on the UK border in France. People are left feeling that they have no choice but to make risky journeys. So that's all the article. Bye bye and see you on my next video. Bye!